There we go.
Thank you, Anne. As Anne said, I am Ashley Bardenquist. I am the Contra Costa County Bar Association Criminal Law Section President, and I am very excited to be presenting the second half, or rather hosting the second half of this fabulous presentation on human trafficking survivors and how we can all help them where they are in the criminal justice system, regardless of how they're getting there, whether or not they are the victims of the case or whether or not they are the accused in the case. It is something that we all need to work together on, as these are individuals who deserve our respect and our help. So with that, just a few logistics. If you have any questions that come up throughout this, please put them in the chat or in the question and answer section. I will then read them. I'll turn on my camera so Emily knows that there's a question pending and I can bring it up. So no need to hold them to the end, but there will be time at the end for questions and answers if you prefer to do it that way. Other than that, if anyone who has not already put where they are, what their area of practice is in the chat, we would like to see that. That way we know who we're reaching, who's interested, etc. And without further ado, I will pass it over to Emily so she can teach us a thing or two about being on her side. And if anyone has any questions or concerns or suggestions for future MCLE events, please don't hesitate to contact me. I will also put my contact information in the chat.
Thank you, Ashley. So hi, everybody. I'm Emily Dahm. I am a criminal defense practitioner. I also do plaintiff's personal injury, but for the purposes of today, we're going to draw on my criminal defense skills. And I practice in a small firm. We're located in Pleasanton, Bonjour, Thorman, Burns, and Dahm. Prior to going into private practice, I was a public defender in San Francisco for about 9 years. And then before that, I did a couple of years in big, boring law. So, but I've been doing the fun stuff for almost 15 years now. So, but I think, for those of you who attended last time, Dana sort of explained that, she and I worked on a pretty serious human trafficking case together. But one of the other things that Dana and I have done sort of informally together is Dana actually educated me about a lot of the ways in which I, as a criminal defense attorney, can actually help my clients who are human trafficking victims, because I had a client, I still have her, I'm still working on this for her, and we get to the end of this, we'll get to these petitions, but I'm working with a client who is a trafficking victim who needs help clearing up some pretty significant prior convictions. And we're going to talk about all the different new laws and mechanisms that are in place that you can use when your client is a victim of human trafficking. And so this is really kind of coming at it from the perspective of the criminal defense community. So we'll just kind of get going. Let's see. Oh, hold on. There we go. Okay. So the headliner is that now human trafficking can be a complete and total defense towards most, but not all crimes. The sort of big takeaways are, if your client is a survivor of human trafficking, if you can establish that your client was coerced to commit an offense, which is not on the list of violent felonies under Penal Code Section 667.5C, and that they acted as a direct result of their being trafficked at the time of the offense, that is a complete and total affirmative defense. Your client is entitled to a not guilty verdict. And Dana, I don't know if you want to talk about how your office takes this into consideration.
So for people who were not here last time, I've been with Contra Costa DA's office for 25 years. I started our vertical prosecution unit for human trafficking back in 2018 when we got a federal grant to start a state, federal, and local task force that enhances its collaboration with victim service partners. So we've had a lot of great technical training and support as a result of getting that grant. And I have had the opportunity to work with a lot of trafficking prosecutors statewide, some of whom are here today, which is great, when we look at the multi-jurisdictional aspect of these cases. I also am the chair of our Family Justice Center Board of Directors. That's a nonprofit. They are state and nationwide. They deal with survivors of all forms of interpersonal violence, which is domestic violence, sexual assault, child abuse, sexual abuse, and human trafficking. So I work really collaboratively on the victim service side. And what we started noticing is that a lot of times my victims are your clients, and your clients become my victims. And a lot of times the group of people that we share, they don't want to tell what their real whole truth is because particularly with sex trafficking victims, that stigma that still attaches to doing commercial sex work. And part of the exploitation is exploiting or manipulating your client or survivor into believing that this is their choice, that you're doing this for us, you're doing this because you want to. And we're seeing a lot of the human trafficking occurring within dating relationships. We have started seeing cases that show up in our office where people were referring them back to me saying, this person says they were trafficked, what do you think? And I let everybody know we need to look at 236.23. The same way I would look at if I'm the filing attorney and I have a bar fight and I'm looking at whether or not there is a colorable self-defense argument, not just one that I think technically attaches, but one that 12 people would be convinced by. And so we have on several occasions looked at cases where we've had survivors tell us that the exploiter says, you're going to get me my money one way or another. You can either engage in commercial sex work, or you can steal. So that becomes labor trafficking, forced services to benefit someone else. We're starting to look now at the intersection of forced criminality and labor trafficking. So if you have a client who was forced, coerced, or compelled to steal, I think about Oliver Twist, the little Fagin out there, who is running a crew of juveniles or running a crew of other people that are down on their luck that are exploited. What about people that are being recruited into gangs to put in their work for the criminal street gang? To what extent is there a defense to some of those crimes that they are being exploited by somebody to do this because they have a reasonable fear of harm at the time that this is occurring, that if they don't do these things, harm will come to them, harm will come to their family members.
Right.
The survivor then is not guilty. And we should consider that at the time of filing as well as during an actual prosecution.
And, you know, not every criminal defense attorney has the ability to know this and to be able to marshal that evidence prior to a filing decision being made. And some of this information may not be available to the prosecutors and known to them at the filing decision time. But if you have that set of circumstances where you have a client, you're aware of their trafficking status, you're aware of how it plays into the accused behavior, you know, that is an opportunity for you to try to reach out to your charging DA and try to do a little pre-charging advocacy to say, hey, you may not know this. Here you go. Let's talk about whether or not this needs to be charged. So anyhow, okay. So one of the, before we get into the details of this defense, let's talk about what it does not apply to. And I'm going to tell you, I got some feelings on this. But there are a lot of crimes that this applies to, but there are a lot of crimes it does not apply to. It does not apply to any crime that is categorized as a violent felony under Penal Code Section 667.5. That's a lot of things that when you look at them, and I just pulled a few out from the list, that you could very well imagine somebody who is a trafficking victim finding themselves coerced into participating either as a direct participant or as an aider and abetter. Okay. So for example, robbery, your client's being forced to go, turn a trick with a John, and, one of their trafficker, one of their minions decides to turn it into a robbery, and she's, the bait. This defense is not available for you for that crime. And as you kind of go down the list, you can imagine the various circumstances in which a trafficking victim can find themselves coerced into what would otherwise be classified as a violent felony. This defense is not available to them at this time. Okay. And, I'm very active in legislative committees for criminal defense organizations. And this is something that I would like to see if there's some way to make this available under the right circumstances for trafficking victims, because I have seen that myself. In fact, my client that I represent right now was the bait for a carjacking. So she has a violent felony strike prior that is going to be there until the law changes. Kidnapping, particularly when your client is involved in a human trafficking scheme where she may be the middle person who is, taking a younger, a minor, a juvenile, a young woman, a young man into the human trafficking scheme at the direction of the trafficker. Residential burglary, they go into an establishment, a home to have sex with the intent to also take some property, some wallets. Anything with an arming enhancement, the 12022.53, and at the bottom you can see the 12022.5.55, which again, if it is gang flavored, there is vicarious liability. So your client would not necessarily have to be the one holding, firing, discharging the weapon. And witness dissuasion, if that is gang flavored, and as we know that the intersection of human trafficking and gangs, it's real and it's there. So just a couple of things I wanted to flag for everybody that, we don't have relief yet for those types of things for our clients who are victims. Yes, question.
The question would be, have you had any experience, I guess, essentially, even after something is filed, or if anyone wants to talk about having the deputy district attorney on the case amend the complaint so that it is not that, once they realize, once you present that compelling evidence that the individual has been trafficked?
I have not had that experience, but you bet your bottom dollar that's what I would be doing. This is just simply saying that the affirmative, you don't get a not guilty if you can prove all of these things for those crimes. It doesn't mean that it doesn't matter. And we're going to talk after we get through the affirmative defense, we're going to talk about the ways in which it may matter and might be able to get you other kinds of relief. Okay. So as I said, it's an affirmative defense. Affirmative defenses are defenses that the defense, we have the burden of proof. It's not the same as the prosecution who has the burden of proving the charges beyond a reasonable doubt. We have the burden by a preponderance, and that's that feather on the scale of justice, more likely than not. Okay. Okay, so there is a CalCrim that's already been issued on this affirmative defense. It's brand spanking new, but we do have a CalCrim on it. And so there are basically three elements. You need to show that your client was coerced, that the coercion was the direct result of your client being a victim of human trafficking at the time that your client acted, and when your client acted, he, she, or they had a reasonable fear of harm. And so you'll see I've got the coerced part highlighted. We're going to talk about that first. All right, so what's coercion? It's defined in the human trafficking statute under Penal Code Section 236.1H1. And the CalCrim basically lifts that language in total and puts it into the jury instruction. And coercion it's either a scheme, a plan, a pattern that's intended to cause somebody to believe that if they did not do something, serious harm or physical restraint would result. So they don't actually have to be beaten. They don't actually have to have things taken away from them. They need to have an honest to God belief that if I don't do X, then these bad things are going to happen to me or someone I care about. Okay. Another form of coercion that is recognized under the law is the abuse or threatened abuse of legal process. So you can imagine people threatening custody issues, calling the cops on people, restraining orders, all kinds of things. So immigration, yes, absolutely.
Deported.
Say that again.
I will have you deported if
I will have you deported. Exactly. Debt bondage. Okay. And then this other one I think is anyhow, providing or facilitating the possession of a controlled substance to a person with the intent to impair the person's judgment, drugging the person. Okay.
I've seen all of these. We've seen debt bondage in the form of we brought you here to do the work and now you owe us for the costs of your transportation. We've seen a young woman being plagued with heroin. So when she stayed with the program, he got her dose every morning. If she didn't, she woke up without her dose and then went through horrible withdrawal. And she thought that this was all her idea, which made it even more challenging. That ended up being a conviction. And then we've seen a lot with immigration, threats against immigration status, and people who have particular vulnerabilities and not knowing what their rights are.
Right.
Fear that if I tell on you, you'll tell on me, that kind of thing.
Right. So these are the 4 different flavors of coercion that this statute recognizes, the jury instruction recognizes, and what you will want to articulate in your affirmative defense for your client. Oh, hold on. I'm always on the wrong screen. Let's see. Okay, here we go. Okay, this is a really important one. Your client's trafficker does not need to directly coerce your client's conduct. So this case is one Dana highlighted, and in fact, if you go and look, you shepherdize 236.1 and or 236.23. All right, the defense. There's only one case that comes up in the citations. It's this NREDC case. It's a terrible, sad case of a minor who was being violently abused and trafficked by an adult man who's giving this kid meth, sexually abusing him, locking him in the trunk of the car. Anyhow, it's a painful read, as these cases often are. And he gets caught with a concealed weapon, a dirk or dagger, and he's in juvenile court. And his lawyer very smartly says, hey, the reason he had a concealed weapon is because his abuser, his trafficker, had dropped him off and said, I know where you are. I can come and get you any freaking time. And you know what's going to happen when I get there. And so this kid finds a knife and he has it concealed on him because he does not want this to happen. He doesn't want to get thrown in the trunk and raped again. And the juvenile court judge said, yeah, but doesn't the trafficker have to direct the bad criminal conduct? And the Court of Appeals said, no, they don't. In fact, it's not even necessary that the trafficker even know that your client was going to commit the criminal conduct. So this is not a requirement. And if you have a judge that tells you it is, or a judge that thinks it is, you bust out this case and then educate everybody and move on.
And the coercion actually flows from your client's status of being a victim of human trafficking. It's such a coercive environment to be in.
Yes.
The prosecutor should understand and not object when this defense comes up with the now canceled argument that, well, the trafficker didn't even know he had the knife. The trafficker didn't tell him to get the knife.
Right.
It can apply if the trafficker says, you need to go commit this crime for my benefit. Right. But it's not only limited to that scenario.
Right, exactly. Okay. All right. So we've talked about what coercion is under the statute, and coercion doesn't have to be directed by the trafficker. Okay, but we as defense attorneys aren't used to having proving up cases quite the same way that prosecutors are. So how are you going to prove that your client is a human trafficking victim? And you got to go back to 236.1. What is human trafficking? And human trafficking is more than just prostitution behavior. It really requires very specific elements, which our friends on the DA side of the table are very used to proving these elements. We, the defense, this is a little bit of foreign territory for us, or we're more used to targeting specific elements. The first thing you're going to have to establish is that there was some kind of deprivation or violation of your client's personal liberty by another person. Okay. And there is a very well-developed and developing body of law about what that deprivation of liberty can be. For example, and Dana, you'll know the cases off the top of your head, but there is at least one. I don't know if it's Guyton or which one. About the withholding your client's children. Oh, you're on mute.
The Guyton case, and that will be in the outline. We put all the annotations in the outline, so you guys don't have to go look them up. So the Guyton case.
Yeah, so the deprivation and violation of physical liberty, don't be too literal about that. Like, this isn't just, locked in a room, handcuffs. Like, it is really, it can be a deprivation of liberty in the mind of, I know if I don't do these things, then I'm not going to be allowed to, I'm not going to get money. I'm not going to be able to feed myself. I'm not going to be able to see my child. I'm not going to be able to go visit my family. That this is really, think broadly about it and read the cases on it.
Really about the creation of dependencies where somebody turns your client or the human trafficking survivor into someone who depends on the trafficker for the necessities of daily living. Without the trafficker, they have nowhere to sleep, nothing to eat, no money. And we constantly battle with our defense friends who come to us and say, this isn't human trafficking because the victim wasn't chained up or wasn't kidnapped or wasn't falsely imprisoned. And one of the cases that's in the outline, the Moses case, draws the distinction. It is in 236, but it's not 236 false imprisonment. It's 236.1. They're different crimes because that's what was intended, different crimes. So one does not require the other.
Right. And so, again, thinking of what that deprivation and violation of personal liberty can be, thinking broadly. And this is one of those things where all those bad cases, when I'm defending the guy or the gal accused of trafficking, suddenly become my cases because now my client's the victim. But that's not enough. It has to, the trafficker has to deprive your client's liberty with the intent to do specific things, to obtain forced labor or services, which again, I think you heard Dana talk about earlier. You can also think a little creatively about, particularly when if your client has to put in work for the gang, they are being forced to, do crimes that are maybe not sexual in nature. It may not be that they are being, forced to work legitimately without pay. They may be forced to do other things, or that the trafficker has deprived your client of their personal liberty with the intent to maintain a violation of any number of specific code sections. And I've listed them here and kind of giving you the basic description. That's enticing a minor into a house of ill repute, pimping, pandering, or transporting a minor for the purposes of engaging them in pimping and pandering behavior, taking a minor from one's parents or guardian in order to put them into prostitution type behavior, all things child porn, possession, creation, and extortion. So as you can see, you need to be able to fit your client into this statutory scheme so that you can then avail yourself of the defense.
Remember that extortion was expanded a couple years ago. It now includes sextortion, which we're seeing a lot with young people, where kids are trading sexually explicit images with what they think is another kid. Turns out it's an adult. The adult then says, I'm going to post this everywhere. I'm going to show other people, or the worst one, we see this a lot, I'm going to tell your mom, unless then you do all these other things for me. And then the kid gets so in over their head, or even the young person gets so in over their head, and thinking that if I just do this one thing, then all of it will stop. And then it's the next thing and the next thing and the next thing. So don't forget that extortion has expanded as well.
That's a very, very good point. Okay. Oh, I went to, all right. So again, what do you need to prove to show that your client's liberty was deprived? Well, it needs to be substantial and it needs to be sustained. Okay. There's no specific time frame. So, but you are going to need to be able to establish that this was not a fleeting moment, but this was something that was of some significance. Okay. That it was accomplished by force, fear, fraud, deceit, coercion, violence, duress, menace, or threat of unlawful injury. That is a grab bag of reasons, most of which will absolutely apply to your client if they're a human trafficking victim. And force is the blunt object amongst all of this, but fear is probably the one that is like if nothing else, fear will apply here, because again, as Dana said, it is cowing your clients into a mindset where they behave in a way that the trafficker wants without actually having to be told what to do. They know what they need to do because they know what the consequences if they don't. And if that's not fear, I don't know what is. Okay.
The case law that we cite in the outline, the Guyton and the Moses case, particularly the Moses case, tells us, the Supreme Court tells us that this is intended to be a broad list. It is not an exclusive list, so you don't have to have everything on this list. Guess what? You don't even need one thing on the list. The list is an includes but not limited list of examples of things that can lead to liberty deprivation. So what we've seen created in case law is the idea of the creation of dependencies. That's not on the list. Depends on trafficker for food, not on the list. But case law says it is part of the totality of circumstances, the big picture that compelled your client to do, or compelled our victim to do something that they wouldn't have done otherwise because they had this reasonable belief that the bad things would come to pass.
Right. And again, the bad things don't have to come to pass. The client just has to have a reasonable belief, and you got to get 12 people to agree with you, but a reasonable belief that the bad thing would happen if they did not do what they were understood that they were supposed to do or were directly told to do. Okay, so this is an important feature of the affirmative defense that you're going to see is different when we talk about the other types of relief that are available for our human trafficking clients. And I think the reason this is different from the other places that we're going to talk about is because what do you get if you are successful in this affirmative defense? You get a big fat not guilty, and you get, we'll talk about some of the other relief that comes with it. And therefore, this affirmative defense only applies if you can establish that your client was a human trafficking victim at the time of the crime. So the fact that your client has a history of being trafficked, it's certainly relevant, would help shore up your case to show that they were a victim at the time of the crime. But what really matters, and what is absolutely a statutory requirement, and the jury is going to be instructed that they must find, is that your client was a human trafficking victim at the time of the criminal conduct. Did I miss one? No, okay. So, all right, how are you going to prove that your client, now you know all the rules, how are you going to prove that your client is a human trafficking victim? Well, if you've ever seen the prosecution prove it, that's a good way to take a few notes, go watch a human trafficking trial and see how the prosecutor is doing it. But there are actually a lot of ways, and you be thinking broadly and creatively about this. So for example, the obvious one is your client can testify. Yes, Ashley.
We have a question. I apologize for popping in. Patrice asked, she indicated, I'm not an attorney, but my understanding has been that for anyone under age 18, force, fraud, or coercion are not required to have trafficking exist. Can you clarify that, please?
It is 100% correct. Penal Code Section 236.1b gives us trafficking for adults. 236.1c gives us the commercial sexual exploitation of children.
Yes.
It does not require the same liberty deprivation element. It includes the inducement, so trying to get a kid to engage in commercial sex work with the intent to do any of those other things on the list. And it includes even attempting to do that as the completed crime. It is intended to be an incredibly broad way to hold exploiters accountable for trying to recruit children into commercial sex. The consent of the minor, irrelevant, because we know kids can't consent to sex. And for years, we've known that there's no such thing as a child prostitute legally. And the exploiter's knowledge of your client's age, not a defense either. And so what we're trying to do is heavily weight the criminal justice system to accountability for adults who drag kids into commercial sex work, because what we've seen is once they get in, we can't get them out. Right. So it's a great question. If liberty deprivation is involved in a case where a minor is induced into commercial sex work, the penalty goes way, way up. It's 15 to life, as opposed to 5 years, 8 years, or 12 years in state prison. So that's a big distinction.
Yes, and thank you so much for asking that question, because I realized I had a slide on this that I just zipped right past. So yes, you're absolutely right. So no, you don't need to have force or fear or menace or any of that stuff. And you don't need to show, if your client is a minor, that there was any liberty deprivation in order for this defense to apply and for them to be acknowledged as a human trafficking victim. Okay, so let's go back. How are you going to prove your client was a human trafficking victim now that you know the rules? As we talked about, your client can testify. Your client's trafficker. I mean, let's think about this. Have they been convicted of human trafficking? Have they been charged with human trafficking or related offenses? Think about your client's trafficker or traffickers, arrests, convictions. Was there any, preliminary hearing testimony against this person? Your client's family, friends, and community members, could be local, like a pastor or somebody they've gone to for help, who could testify about what your client was experiencing at the time of the crime. Other human trafficking victims of the same trafficker or traffickers. And let's never forget, this is one of those times that we as the defense, the police are our friends. What about all of the cops who may have contacted your client over the years, or the other victims that the same trafficker is moving about, or the trafficker, him or herself? So one of the things that I would say is to be really, really thoughtful about what records might be out there that pertain to either your client, other people who've been trafficked by the same trafficker or the trafficker. There are police reports, and I will tell you, you might look at your client's rap sheet and see some police contact and think that it's just a total irrelevant nothing burger. Please don't. I encourage you to send a release and a request for your client's arrest records, all of them. In one of the cases that I'm working on, I'd sent a request for a police report from Santa Ana from like years ago, just years and years ago, that looked like nothing. The charge on the arrest seemed absolutely irrelevant to human trafficking. And when I got the report, it was like reading like a screenplay for how my client was being trafficked, and the organizational scheme of the middle guy was there, and he was the guy in the car that my client was going to talk to when the cops were watching her trying to pick up guys. And she had a concealed weapon on her, and she explained why she had a concealed weapon on her. I mean, it was just an absolute treasure trove of evidence gathered by a police officer that established how far back my client had been being trafficked, and how it wasn't always just the top trafficker who was moving her around, how there were these mid-level traffickers who were moving her. Anyhow, be creative, think broadly, get every single police report you can related to your client's trafficking, whether it's her reports or anybody around her's reports. Under 236.2, I think that's probably under 236.23C. This says that when you're doing the affirmative defense that your client was coerced into committing a crime because of their human trafficking, that you may use certified records from pretty much any kind of governmental agency, that includes immigration, which documents your client's status as a victim of human trafficking at the time of the offense. This is a big umbrella, okay? Have they put in for public benefits and said something about this? Think really broadly. 236.2 actually puts a duty upon police officers that when they are encountering someone that they believe to be a trafficking victim, that they are to document and identify that person. Those records are also can be used to prove up your client's status, but importantly, let's say the cop didn't get her name, or it doesn't matter if they failed to ID them, but maybe they described them. This is still evidence you can use. And then just going back, because I skipped over it, experts. And your expert can do a couple of things. An expert witness who could be an academic, it could be an advocate who works in the human trafficking community, it could be a counselor, it could be a social worker. Your expert can not only review, interview, and attest to your client's status as a human trafficking victim. You'll see when we get to the next part, that expert should also be able to help with the direct result part to show the nexus between why somebody experiencing what your client experienced would then do the criminal conduct that was that they're being charged with, and how that was very much not in your client's control. Okay.
I just put the statutory reference in the chat. It's Evidence Code Section 1107.5. It's a newer section. It's sort of modeled after the battered women's defense. So we see in domestic violence cases where a previously battered spouse has an unreasonable belief in the need to use self-defense because of the context of the violence that has gone on for so long. And we have an expert who explains why someone in that situation has the perceptions of extreme and immediate harm coming to them that would make them feel they have the need for self-defense, but when the abuser is asleep and they stab him in the back. And that would not normally be self-defense, but in this context, we expand it because we need to understand what the survivor has gone through. So the same way Evidence Code Section 1107.5 lets either side, it lets me use this when I'm explaining, for example, why my victim stayed with her abuser. Why did my victim, if this issue is really being forced to sell sex, then she should have just walked right out that door, right? That's what I would have done. That's what 12 people think. And
Sure.
I explain why she didn't leave. Emily can turn around and say, this is why she didn't leave the exploiter. And also this is why she continued to engage in other criminal conduct at the demands, the requests, the coercion, the persuasion of that trafficker as well. So it's important for both sides of us in the criminal justice system to understand how experts really can help the finders of fact understand what it's like to be in that trafficking situation and have to make decisions.
Yeah. Okay, let's see. Here we go. Okay, so we've talked about one, how to establish coercion. We've talked about part of two, which is how to establish your client was a human trafficking victim. But there's a lot of things packed into number two, including that you must prove by a preponderance that your client's criminal conduct was the direct result of them being a victim of human trafficking at the time. And so, okay, what the hell does that mean? What do you mean by a direct result? Well, 236.23, 236.1, you read all the 236 points. They're really big, long statutes. They define all kinds of things, and they don't define what direct result means. It's also not defined in CalCrim, on this. And as far as I can tell, there is no case law on this yet. If I'm wrong, please let me know. So then I thought, well, gee, okay, does this mean it's the same as kind of like causation? And it probably is something akin to causation. But one thing that I think is really interesting, because again, I also do civil. If you look at the jury instruction for causation in the civil jury instructions, which I put in here, it's KC 430. Causation requires that it would require that the human trafficking be a substantial factor in your client's conduct, but it doesn't have to be the only factor. Okay. So I would encourage practitioners who are trying to avail themselves of this defense right now to think really broadly and don't let yourself get pinned into it has to be direct cause, only cause, sole cause, and then effect. That if you can establish that the human trafficking scheme in which your client was stuck inside of and was being coerced by was a substantial, major contributing factor to their conduct, their criminal conduct, I would expect that should be enough to get you to direct result. Okay. At the end of the day, it's really going to be up to a jury to decide that, but you're going to have to hold that jury's hand and help them figure that out. Okay. The bottom line is you got to show what is the nexus between your client being a human trafficking victim and your client's criminal conduct. And lastly, for this affirmative defense to apply, you're going to have to show that your client had a reasonable fear of harm at the time that they acted. And Dana mentioned the the evidentiary or the rule of evidence allowing that kind of testimony about fear and harm, and that will go directly to this element. That will go directly to this element. Okay. All right, so let's say, you know, boy, this human trafficking stuff is a lot of elements. My client doesn't fit quite totally into a human trafficking victim as defined under the statute. What do I do now? Because it's pretty close and they were definitely coerced. And look, first of all, coercion is an affirmative defense just generally under the law. Okay, so don't give up that it is an affirmative defense. All right. But it is also an affirmative defense for victims of intimate partner violence and sexual violence. It's not just human trafficking that this applies to. So if your client doesn't neatly fit into, or your concern doesn't quite meet all the elements of a human trafficking victim, are they a victim of intimate partner violence or sexual violence that would otherwise apply here? And if the answer is yes, then carry on. If you win, you go to trial, you bring this affirmative defense, the jury says not guilty, huzzah, you've won. But you've won in more ways than just the not guilty verdict. If you prevail on this kind of defense at trial, it triggers a series of sort of record cleaning provisions. Your client's case records must be sealed under Penal Code Section 851.86. Although be aware that law enforcement can still use those records, including those police reports, to investigate other people, not your client. The charge is deemed not to have occurred. Your client can, with a straight face and a calm heart, say, I've never been arrested, charged, or convicted in that incident. They cannot be denied benefits as a result of this, and they may not be charged, let alone convicted, of perjury if they deny that their arrest or charge ever happened. So, and I think about that on the flip side as a defense attorney. If I'm defending a trafficker, you know, if someone has prevailed on this defense, that's not perjury for them to straight up sit on the stand and say, nope, never happened. Okay. Okay. So let's say we're not at trial. We're not doing an affirmative defense. We're trying to negotiate because our client is a human trafficking victim, and gosh darn it, the prosecution should know this and should factor this into the plea negotiations. Well, good for you, because now the penal code says so. Penal Code Section 1016.7 says that in all plea negotiations, the prosecutor is now required to consider, among other factors, the following things. Did your client experience psychological, physical, or childhood trauma, including but not limited to abuse, neglect, exploitation, or sexual violence? Is your client a youth? And now, was your client a victim of either intimate partner violence or human trafficking prior to or during the commission of the offense? Okay, so prosecutors have to consider it. It doesn't say what prosecutors have to do with it, okay? And obviously the burden of persuasion at plea negotiation stage is always on the defense, but all of those things that we talked about improving up the affirmative defense are all things that would make a very compelling mitigation packet for a prosecutor to say, let me tell you about my client. And one of the things you talked about last time, Dana, was I think with Jesse's case, where you had come to an agreement with him. And I actually, this is another pet project I'd like to see legislatively. In civil, you can have there's an evidentiary privilege over settlement conversations and materials provided in settlement. There's no such thing in criminal, which I think is insane in the membrane, because a lot of times I want to tell my prosecutor things that, you know, I want to know that if I tell you these things, and let's say through our good faith effort, we just can't settle the case and we still end up in trial, you can't use those things against my client. But I want to be able to put my cards on the table with you. And this may be one of those situations. And so there's no rule giving you that privilege, but boy, it's a real good idea if you want to see if you can get that kind of an agreement with a prosecutor so that you can put on the table the evidence you need to about your client's trafficking status, which is almost always going to involve criminal conduct.
This is where I came down when talking with then public defender or alternate defender Jesse Shea about his incarcerated pregnant 18-year-old trafficking victim who I had charged with life crimes for trafficking another minor and threatening her in a recorded call in an interview room. So she had literally no defense. He needed to explain things to me so that I had the big picture, the true picture of why his client was doing what she was doing, and why it was fundamentally unjust for her to be held to the same level of accountability as her co-defender, the adult trafficker. And it really, to me, it came down to due process, right? It's the defendant's due process right, due process right. I also think when I used to run the domestic violence unit, defense attorneys had a statutory obligation and definitely a bar rules advocacy obligation to try to mitigate immigration consequences for their clients, and everything domestic violence gets your client deported.
Yep.
And so I had defense attorneys who needed to tell me things, because if they didn't do it right, they would be up on bar charges potentially. So I think now the creation of these statutes, this new statute, Penal Code Section 1016.7, gives our defense bar an obligation to do these things. And if they don't do them, then they are in violation of their duty of zealous advocacy, and they might be running afoul of business and profession code violations that impact their bar cards. And so knowing all of those things, and given prosecutors on the call, that we all have the same shared goal of allowing survivors of human trafficking to move past their victimization and out of this life, then it makes sense to, what we did was we just agreed in writing, right? He asked me in writing and I answered in writing that I will not consider this information for any purpose other than plea negotiations, because then it's an inducement. The client waives this right to have the confidentiality of this information. And we even talked to his client with this understanding in writing. If I welch on this deal and the defense shows what I wrote to any judge in the land, it's not coming into evidence. Right. Because it induced the defendant to give up a constitutional right in exchange for what I promised and then lied about. So for prosecutors, we shouldn't be making those agreements unless we intend to keep them, because there will be consequences for us if we don't. And should we avoid making those agreements to find out the truth when our job is to seek truth? I don't think we should. I think we should be very generous in agreeing to take on mitigating information so that we can get to a just result and not then punish the person for trying to get there by slamming them within a trial.
Yeah, and I have to say, from the defense perspective, we do feel caught between our clients' competences, our duty to effectively advocate for them, to maybe not preview coming attractions, which might be our defense if this plea negotiation process doesn't go well. There are a lot of moving pieces, but I will tell you there would be such a greater comfort level for us to really go all in at the plea negotiation stage, in the mitigation stage, if we could assure our clients and ourselves that this is for this discussion only. It stays here only. If it doesn't work out, we gave it our best, but it's not going to come back to bite my client in the ass down the road when we were back to fighting the case. So in any case, but the reality of the situation is prosecutors have to consider this stuff. Now, how they consider it and what weight they give it, I mean, obviously this is up to them, and it's also going to be based on, well, how compelling a series of facts and circumstances have we provided the prosecutor. So we have a question, Ashley? I saw you pop up.
I just answered.
We did, but it looks like Dana answered it in there. I know that. So just if anybody didn't see the question, just so I can bring it up, there was a question about building resources, about finding an expert who will testify as to the effects of human trafficking on human trafficking victims turned criminal defendants. And Dana posted a name and individual who you can look to for that.
She's a professor at the University of Utah. Her name is Annie Fukushima. She first testified as a defense expert at the for the San Francisco Public Defender's Office. She has most recently authored an incredible book that everybody should read called Migrant Crossings, which looks at the vulnerabilities of transnational migrant workers and how they are super susceptible to being induced into labor trafficking and probably sex trafficking as well. She is the routine expert in my labor trafficking case, and it has been wonderful for us. Her curriculum vitae is phenomenal for both sides. And another person that you can look at as a potential expert in the case that that Jessie Shea represented, the 18-year-old incarcerated pregnant trafficking defendant and charged victim. He did not know this, but she had a trafficking counselor who had the statutory confidentiality privilege. And so we discussed this, that all privileges can be waived. And the waiver came with my express written agreement to not use the information from the trafficking counselor for anything other than settlement negotiations. And she wrote a phenomenal letter, basically corroborating everything this young lady said about her trafficking experience and giving me an opinion about why client did what client did. That was really profoundly impactful in helping me make the settlement decision that I did, which was in this case, I think next she's on in 2 weeks. If she did everything she was supposed to do, we will stipulate as though a vacatur petition had been successfully filed and granted, and every single thing is wiped off this young lady's record.
Yeah. Okay, so let's say you've been successful, you've persuaded your prosecutor, you're going to get the deal of a lifetime now for your client because you've just been so amazing and you've just done the best advocacy ever for your client. Don't forget, Marcy law is still out there, and the victims of your client's behavior still have a right to be heard, to attend sentencing and basically any other proceeding, and to object. Okay. All right. Another thing you may have noticed is that the standard under the 1016.7 is a little bit looser than it is for the affirmative defense, which makes sense because you're not getting a not guilty here. You're getting a mitigated sentence or disposition. So there are some significant differences. The statute only requires that the fact that your client is a human trafficking victim contribute to your client's alleged criminal conduct. You are not bound to the direct result standard in order for this to be relevant and legitimate and valid material for a prosecutor to be required to at least factor that in to plea negotiations. The other thing that's a little bit looser is, unlike the affirmative defense, where you have to establish that your client was a human trafficking victim at the time that they acted and did the criminal conduct that they're accused of, previous human trafficking, even if it wasn't going on at the time of your client's conduct, is relevant. So it's either prior to or during the commission of the offense. And that makes sense, right? Because we all know that just because someone is no longer being actively human trafficked doesn't mean the effects of going through that awful experience turn off like that. Okay. Okay, at sentencing. So, all right, we failed to persuade the prosecutor. Let's say we've even failed at the affirmative defense, but here we are. Okay, we're at sentencing, and your client is facing the judge who's going to decide what they're getting. Now, under 1170B6C, one of the factors that the court must consider as mitigation evidence at sentencing is whether or not your client was a human trafficking victim or victim of intimate partner violence, if either of those things were, again, lower standard, contributing factors to their criminal conduct, and that they had that status prior to or during the commission of the offense. If those things are established, the court must sentence your client. If they're going to sentence them to prison, so if probation is out of the picture, it's low term. Now that can be overcome with aggravating circumstances. So if there were significant aggravating circumstances, it could overcome that presumption of low term. But this is the law now. Okay. And again, as we know, even if the judge decides that these factors are present and that they compel a sentence of low term, victims are absolutely entitled and will be permitted to voice their thoughts on this topic and their objections at sentencing. Okay, perfect. Last. All right, so we've talked about how you defend your client at trial when they're a human trafficking victim. We've talked about how you can use their human trafficking status as mitigation and for plea negotiations. We've talked about how you can compel a court to take this into consideration when choosing a sentence for your client. All right, now your client has convictions. They're done, they're over. Your client has convictions. Is there any relief for them? Yes, big time. Penal Code Section 236.14 is a statute which provides for vacatur. And, you know, vacatur is just the best. You know, you've got expungements, you've got sealing orders, all of those things are great. But vacatur is, you know, the ultimate eraser. I call it like you're getting in the go back in time machine, and you are erasing the fact of your client's conviction in its entirety. Okay. If your client is a human trafficking victim who was arrested or convicted of a non-violent offense, so remember that big list of things that this does not apply to. For a non-violent offense, they are entitled to file a petition for vacatur with the court. You serve it on your prosecutor's office. And the petition must show by clear and convincing evidence, again, this is the defense's burden, that your client's prior was we're back to direct result, was the direct result of them being a victim of human trafficking at the time of the conduct, and that your client is making a good faith effort to get out of the human trafficking scheme. So we're back to direct result at the time of, and of course, think about the relief that your client is getting. That's why the standards, I think, are that high again, is because your client is getting a complete and total wipeout of a prior conviction. One thing that I think is really important to note is this last bullet. Your client does not have to be totally free from the human trafficking scheme to be eligible. What you need to show is that your client is making a good faith effort to get out of the human trafficking scheme. So they don't have to be perfect. They don't have to have stuck the landing. They just need to show that they are sincerely, genuinely trying their very best. Once you file the petition, and again, well, let me back up. Where do you file the petition? You file the petition where the conviction was sustained. Okay, so this is going to go back to the county where your client sustained the conviction. The prosecutor is
the statute actually says you can file, because trafficking can be multi-jurisdictional. You can file them in any county, but there is no means by which to achieve the relief that your client needs, because counties don't talk to each other. So if you file, the one that I did, it was multiple DUIs in every single county, and they tried to file them all at the Alameda DA's office, except an Alameda judge can't give relief to a Contra Costa conviction. There was supposed to be a judicial council form or judicial council rules to address this, but they really can't, because sometimes legislation is written by people who don't do our work and they don't know this fact.
And then just think about
is just to do them in each jurisdiction.
Absolutely. And think about, I mean, I've even had issues where just the record keeping. Okay, so like you're going to file a petition in a county for a conviction that wasn't sustained there. You're going to get some dummy docket number. You're going to get an order with a dummy docket number that isn't going to relate back to the docket where your client was actually convicted. So when your client goes and gets their rap sheet and DOJ gives them a rap sheet that says this conviction's still there, they're going to say, what the hell? I thought this was dealt with. You know, I've had this issue on expungements where I've had a client who's had a probation transfer. Well, on a probation transfer, the old county loses jurisdiction over the case. I cannot file an expungement petition in the originating county. I can only file it in the county that has jurisdiction, which is where my client is a probationer. So I have had successful petitions to expunge that are still showing up as my client having had this conviction and it not being expunged on his rap sheet because it's a different docket number. So just as a practical matter, file these where they occurred. There will be an existing docket number, and that court has jurisdiction. The court records are there. I mean, hopefully, if they haven't been destroyed, but if they've been destroyed, there may be some remnant in their system of the prior case. But yeah, this is not a one-stop shop. You're going to cost yourself a lot more work and trouble. The prosecution has 45 days to file an opposition after you file the petition. One of the things that you should do before you file a petition, I would strongly recommend, is to reach out to your whatever prosecutor's office you're going to be filing this petition in, and find out if there is a DA who is in charge of their human trafficking unit and who handles these petitions. Because my experience is, and again, it's limited, so I'm not speaking for statewide. I know in Contra Costa and in Santa Clara, I'm almost 100% sure in Alameda as well. The best practice is to probably talk to the prosecutor who would be handling this, and I've given them my petition as like an informal look. Take a look at this. What do you think? Are you guys going to oppose? And the answer may be like, no, looks great, not going to oppose. Great. Or it may be like, you know what, you're close and we might not oppose, but I need a little bit more information on these following things. And then I can beef up the record to satisfy the prosecution. And then we can go, holding hands into court and saying, Judge, here's the petition, there's no opposition. And I think any criminal defense attorney knows that when the prosecution's on your side, things go real smooth in court.
I worked on one where we spent probably 3 months having it go back and forth because they did a really good job of showing their client had a terrible pimp, but had not proved that she was a survivor of human trafficking. And I had to revert them back to, I sent over case law, I sent over the statute, I sent over the jury instruction. And my interest in doing that is, guess what? I don't want to go to court a bunch of times, because if the court denies it, the denial is without prejudice for it to be refiled again and again and again. So why don't we work offline to get it right if they're going to be able to get it right? If I really think you won't ever be able to get there, I'll let you know. One of the problems I was having too was with the quantum of evidence produced by the defense. Great, very lengthy declaration from client, but my filing standard is I need corroboration. So it can't just be my victim's word, because that's not enough. I needed it to be corroborated. That's why in Jesse Shea's case, I just saw that Jesse's actually on this.
Yeah, I saw that too. Hi, Jesse, if you're still there.
I told Jesse, I need to do what I would do if I was filing this. I want my investigator to talk to your client. And it was the middle of COVID. And so we had to do this over the jail phone, and Jesse had to be there with his client. And once again, we agreed that her statements to us would not be used. We agreed to this in writing for anything other than settlement negotiations. And I got her story from her, not what the lawyer says his client says. It's nice when you tell me what your clients are going to say, but it's not enough. And so, when we got to the other petition that I was looking at, it wasn't enough. And they went back and they got her human trafficking caseworker to author a declaration. And she also was seeing a psychiatrist, and they had that person author a declaration. And I know under 1107.5 that that's admissible. And so if we can get there, I'd like to see us get there. The other challenge we have with the DUI case is I understand how alcohol and controlled substances are used to deal with the trauma of surviving human trafficking. But the two elements of the crime you want to vacate are driving while under the influence. Why'd she have to drive? Not to be glib, but she could have done in-calls. Why did she have to drive? You need to answer that. I'm not being difficult, but I need to set a threshold that once I grant yours, I have to grant everybody else's that are like yours, or not oppose everybody's that are like yours. And so they went back to their expert and had a better explanation of the particular factual circumstances for this young lady, and how one of her Johns owned her car and wanted the girlfriend experience. And if she didn't drink with him, then she'd get in trouble. And if she didn't come back with the money, then she would get beaten by her pimp. And that was enough for me.
Yeah. And one of the petition that I've got pending right now, I will tell you, in my opinion, having now worked through one, and I don't have an answer yet, so I don't know if I've stuck the landing yet. I don't know if I'm going to get sent back to do more work. But it's huge. It's a huge petition because it is like there is my client's declaration, which is very lengthy and sad and upsetting. But there is all the other things that we've included as sort of support. Like when I'm talking about these places where she was forced to engage in forced sexual services, I'm pulling Yelp reviews from these places where people are just straight up talking about what goes on at these places to kind of corroborate the fact that, yeah, I know this says coffee shop, it ain't a coffee shop, right? And then also evidence of the efforts my client has made to move away from the trafficking scheme. But Dana's absolutely right. This vacatur statute applies to any conviction except for a violent felony. And that's a lot of stuff. And in my case, it's also, my client also has like tons of DUIs. And so having to explain, okay, I understand the drinking. Very, very easy to understand that. I don't know how you could do this, go through that experience sober, honestly. But why the driving? Why did you have to drive? How come you couldn't take an Uber? How come somebody else couldn't? Like, I've got to ask my client these questions because I know that the prosecutor is going to ask those questions and we're going to need to have those answers for them. And the answers were actually quite logical once I put it to my client. Like they don't have credit cards. She doesn't have a credit card. She can't have an Uber app. You think your trafficker is trusting her with a credit card and an Uber to go wherever she wants? Absolutely not. 2, not letting her get in cars with strange men. 3, she has to drive the other girls have to drive her, and they're all hella drunk, okay? Because they're all using during all of these parties and call-ins and all of this stuff. And so there were really very, very logical reasons for why it was not an option to have somebody else drive you. Anyhow, so think, again, think creatively about your client's priors and talk to your client, spend a lot of time with your client, understanding what their priors are and whether or not you can tie them to their human trafficking. And if you can, and it's an eligible offense, you should. It is a lot of work. But it is one of those petitions that I think that most prosecutors would welcome and are actually going to want to. So if your client is a human trafficking victim, they're going to want you and your client to be successful and are probably going to be very, very, very much not adversarial, but more assisting. In fact, I would hope that's been my experience, and I would hope that that would be how any prosecutor would be for what looks like otherwise a pretty righteous petition. And then if you're filing the petition, you're going to have a hearing on the petition. The court can allow your client to appear through counsel. So you can 977 this, or they can appear telephonically if there's a compelling reason. You can imagine many circumstances in which a victim does not want to go into court at all, talking about this stuff, being identified as bringing a petition of this type, particularly if they've made statements in their declaration or their petition that might identify or implicate their trafficker. They are probably going to want to keep a very, very low profile, and the statute specifically says, okay, we'll help you do that. We're so used to, on the defense, the judge saying, well, have you paid all your fines and fees? Is the restitution paid in full? Well, you can't bring this petition until then. Not for a vacatur petition. Now, if you get a vacatur petition granted, it does not relieve your client of the obligation to pay victim restitution. It's still got to pay victim restitution for the crimes that they committed, but it's not a basis for the court to just outright reject you for even hearing the petition. Let's see. Okay. Petitions can be denied without prejudice. Obviously, anytime I lose a motion, I want that to be without prejudice. And you can try again. You can have another bite at the apple. But as I think we're learning, these are very labor intensive, and they're also emotionally intensive petitions to file for your client to go through. So it's always best to get it right the first time if you can. If you win, like I said, this is the big eraser. You're going in the back in time machine, and the court is ordering the guilty verdict set aside. It's dismissing the charges. The records are going to be ordered, sealed, and destroyed. Your client can say with a straight face and a calm heart, I was never arrested, adjudicated, or convicted of that bullshit. Nope. And they may legally deny or refuse to acknowledge the existence of that prior arrest conviction. This is also really important, particularly for folks who are moving on. The records of their prior may not be distributed to any kind of state licensing board. So if you have a client who was a prior victim and they've moved on, they've gotten this vacatur petition, their prior records may not be provided to a dental licensing board, a medical licensing board. If they're trying to get a massage license because they're going into legitimate massage therapy, you know, all you can imagine all of these different, let's say they're trying to pass the bar. So this is a very, very, very comprehensive cleaning and erasing statute. And it's one that I think I didn't know about. It's been on the books for a few years. I had absolutely no idea about this as a defense attorney. And I'm almost like a preacher on this now, because I want all of the defense bar to understand that when you have a client who is a human trafficking victim, and we do, there are a variety of things you can do to drastically improve your client's experience in the criminal justice system, and you can actually help clean up their prior record. And I'll let you want to talk about resources? Oh, unmute yourself.
I'm on mute. Okay. Collaboration is key. I have one role to play. I am not the only thing that will save the world for a survivor of human trafficking. They may need a defense attorney. They may need a civil attorney. They may need a family law attorney. They may need an advocate. They may need an immigration relief. And so what we ask people is, if you see something, say something. So our survivors can call to get help, local help. We try to deter people from calling 800 numbers. Polaris is a phenomenal organization, the National Human Trafficking Hotline. I've been to their call center. It's in Washington, D.C. I had to sign a non-disclosure agreement to go inside, so I can't tell you where it is. But if you call there, you get a human being, which is terrific. But the human being asks you where you are, and then they look at the list to see who the service providers are in your zip code. And I don't think any of our advocacy organizations currently are on that list. So we have community violence solutions that works in both Contra Costa and Alameda counties. I know there's people from Sacramento and LA and other locations here. So you guys have your own awesome organizations, but this is what we've got locally. If you've got a child who is being sexually exploited, then you need to call Children and Family Services. Here are the numbers in Contra Costa and Alameda County. The national hotline I put down here for you also, or sometimes we have people who cannot take the phone and put it up like this without getting beat. So you can text to be free that you need help, and you can get help that way. And then our community members can report. Alameda's Heat Watch, which is the Human Exploitation and Trafficking Unit. They have a much snazzier acronym than do we. They have a tip line. So does the Contra Costa DA's office for our Human Trafficking Task Force. Those numbers are here. And also a stakeholder. I know Christina's here from our social service department. So if you're an advocate or a community member, you can nominate a trafficking case to a human trafficking multidisciplinary team. That is a group of multidisciplinary stakeholders that are authorized by law in California to discuss what otherwise might be confidential. We were so siloed, we could not work together to solve the problems of our clients. We started doing this for child abuse survivors, and then elder abuse, and then domestic violence, and actually helped write the law for human trafficking. Instead of putting it in the Welfare and Institutions Code, where none of us ever go, prosecutors and defense attorneys, we put it in the same statute that authorizes family justice centers. So you will see the statutory authorization for human trafficking multidisciplinary teams. If your county doesn't have one, start one. In our county, we have started having the public defender present cases because they have a client that they represent in juvenile who is being trafficked. and needs resources and support beyond what the public defender can get on their own and beyond what Children and Family Services has been able to get on their own. We all need to be a big, giant community working together for survivors of human trafficking. In Contra Costa County, you can contact Natalie Olias at our Family Justice Center. One of the reasons we organize them through Family Justice is if the DA's office did it, the public defender would never show up. Certain stakeholders would feel uncomfortable if it felt like law enforcement, which is why we have Family Justice do it, because they are a sort of neutral Switzerland kind of partner for us. Next slide. And here is all of the organizations that are direct service providers for survivors of human trafficking in Alameda and Contra Costa counties, because that's where Emily and I primarily work. I'm super excited that we have so many people from all over California. So you probably know where yours are, but if you have a survivor who also has been in or around our area, these are the advocacy organizations that can assist your client. Because a lot of times we have girls who come from Contra Costa, they're on a circuit, they go to LA, they go to Sacramento, and they're out on a blade there, or they're doing itinerant work and they're traveling to various locations. So when they get home, they may still also need advocacy organizations. Next slide. Are we done?
I think that's it. Oh, wait.
Okay.
Oh, one more.
It's the one that says DA's webpage and Alameda County, our web pages also have information. Patrice is saying something about Missy, has 3 somethings.
3 S's.
I don't know what that means.
It means that we don't have enough S's in the acronym. We'll fix that.
Oh, thank you. Got it. I should know better since we've worked with them for years. Anything else? Emily?
No,
Right at time.
that's a lot, and that's a wrap.
Thank you
you guys.
so much.
This was amazing, and I'm so glad we got it off the ground. And I'm gonna
Does
hold on.
anybody have any questions? I know we just have a couple of minutes left before we go. We could probably fit one if anyone had one. I don't see any.
And if you have questions later, please feel free to reach out to us.
You will get the slide deck. You will get a handout from us that has all of the statutory references and the case law that we referenced. I think on here you have my email address and Emily's email address, and I have no problem at all with anybody reaching out to me because we do defense attorneys, advocates, social service, prosecutors, the courts. This is probably one area we all have in common where we want to see these survivors move past being victims and into recognizing their full potential as human beings in our communities.